Okay, well, let's get started. So thank you everyone for attending today and spending a part of your Thursday with us. I am Mia Dunn. I am the Senior Director of Philanthropy at Pasadena Humane, and planned giving is one of my responsibilities here. A little later in the webinar, I'm going to speak about including Pasadena Humane in your estate plans and the various ways that you can do that. But whether or not you are planning to make a planned gift to Pasadena Humane, I do hope that you find this webinar helpful. It's full of a lot of information about estate planning, and particularly about including your pets in that plan, which is very important. So now I would like to introduce our presenter today, William Hayes of the Hayes Law Firm, in South Pasadena. Bill is originally from Chicago and moved to Los Angeles as a young boy, and he grew up with pets. His first dog was a brindle boxer named Duke, who was adopted from a local shelter. Bill graduated from the UCLA School of Law, where he served as senior editor of the UCLA Law Review. And among the many hats he has worn since then are member, editor, and grader of the UCLA Moot Court Honors Program, associate editor-in-chief of the National Law Journal, a syndicated newspaper columnist writing about estate planning topics, a contributing author to several books on estate planning. And of course, he's founder of the Hayes Law Firm in South Pasadena, where he handles estate and business planning. Bill is currently a member of the American Academy of Estate Planning Attorneys and the Estate Planning Council of the San Gabriel Valley, among other groups. And outside of the field of law, Bill has tried his hand at comedy. He studied stained glass design, he travels extensively, and he also plays the flute and practiced martial arts, for 20 years and has earned his black belt. Prior to founding the Hayes Law Firm, Bill was a lawyer in the film and music industry. And so now I'm turning it over to you, Bill. Thank you.
Thank you, Mia. Thank you very much. And thank you everyone for joining us this morning. We are going to talk about estate planning with an emphasis on pet trust. We will begin the presentation in talking about the pet trust, and we will follow that by a more general discussion about estate planning. Now, this presentation is being made possible through the generosity of Pasadena Humane and through the consistent efforts of Mia Dunn, who is the Senior Director of Philanthropy. On the screen, you'll see a bit about my background, both educationally and professionally. I have been an attorney for well over 30 years. As Mia mentioned, I started out in the entertainment industry, but for at least the last 25 years, our emphasis has been on estate planning. Our law firm has been located for, I believe, the last 24 years in South Pasadena. We're located in the historic Behringer Studios building, which is located at the intersection of Orange Grove and Mission Street in South Pasadena. It's a beautiful old building, and maybe someday you'll come to visit us. So let's talk about planning and how it is important that you make considerations for your pet in any estate planning that you've done. And if you already have an estate plan in place, you need to consider how you will want to look at amending that those documents to include your pets. Our pets become like parts of our family. In a survey conducted by Kelton Research, 81% of people surveyed said that they felt that their pets were just like family, equal in status to their own children. Now, the American Pet Products Association, on the other hand, says that even though people feel that their pets are like family, only 9% of people have made provision in their trust for the care of those pets. And that's a problem, because the number of pets which are abandoned, pet companions which are abandoned every year is like over 7.5 million pets every year. So and oftentimes that's as a result of people becoming ill or passing on and nobody having made provisions for the pets. And of course, that's not exactly fair when you know that the pets have given unconditional love, and at a time when they most need it, they're left to their own devices. And that can be a problem because sometimes that can be a very bad end for those pets. Your pet depends on you. And you want to make sure that if you should become disabled, or if you, when you die, that you will have a plan in place to care for that pet. And if not now, when will that happen for you? When? Because you never know what's going to happen in your life, whether it be disability or death. You need to have a plan of action. So, pardon me 1 second, there's something in front of my screen. I need to move that. So, in the event of any possibility of disability for you, you want to already have named the people who will be in charge of your pet's needs. It's important that when you do that, that you have a discussion with that intended pet caregiver. Not only is it reasonable to do that and consider it, but it's also required by law that you give notice to the intended pet giver of their having been named in your estate documents as the person that will take care of the pet. When you do planning for pets, there are 3 primary documents that need to be considered. Those documents would be either a power of attorney, a will, or a trust. Now, if you look to use the power of attorney for your planning for your pet, just know that the power of attorney has limited application because the power of attorney is only effective during your lifetime. Powers of attorney terminate when you die. So if you're disabled, the power of attorney is a good thing. You name somebody, they'll take care of the pet while you are unable to do so for yourself. And when you recover, the pet comes back to you. But if you should die, there are no controlling documents if all that you had was a power of attorney. So when you name someone as a pet caregiver with the power of attorney, it may be that you give them not only control of the body of the pet, the physical needs of the pet, but you may want to set up some type of fund to care for the pet. The second type of choice for planning is the will. We all have a general sense of what a will is. But basically what a will is something that goes into effect when a person dies and describes to whom the estate will be distributed and who will be in control. A will must go through the probate court system in California. I know some people believe that if you have a will that you don't have to go through any process. Well, that's quite to the contrary. If you have a will, you must go through the probate court system, which can be really an arduous thing to do because in California, particularly in Los Angeles County, it's taking on average about a year for even the simplest of wills to be probated. And when you go through the probate court process, of course, there's high fees, court costs, attorneys get a percentage of your estate, as do the administrator of the estate. They also get a percentage of the estate, and this is by state law, by the way. And it's open to the public. When you have your estate probated, your affairs become a matter of public record. So, of course, that's not something that most people would want to happen, but that is what happens when you have a will. And as that pertains to your pets, what that means is that that year that it might take for this a simple probate to occur will mean that the pet won't have any financial resources until the estate is fully probated. So that may not be the best way for you to consider planning for your pet. Now, when you compare the will to the trust, in my opinion, and I think in most estate planning attorneys' opinions, the trust far outweighs the will in terms of benefits to both you and to your pet. Because where the will take a long time for the pet to even receive any money for its care, the trust can be affected immediately. Monies can be made available for the pet's care, and there won't be any lapse in the needs of the pet. Now, you can use either the will or the trust, but I don't think that there's any comparison between the two. You always will want to choose a trust for the care of your pet. The trust is better than a will when planning because one, the will takes a long time. Two, the probate court system can take months and even years to get through before the estate is concluded, depending on what other assets you may have in the estate. And on the other hand, the trust can be implemented immediately. And in addition to that, when you have a trust, the caregiver that you name as the person who will care for the pet can be subjected to legal consequences if they choose to ignore the requirements of the trust. So if they start using the monies for other than the needs designated in the trust, there can be legal consequences to that person. In California, as in most states really, pets, though we know them to be considerate, kind, living creatures, the state thinks otherwise. Pets are considered personal property in California, just like the car in the driveway is your personal property. And therefore, you cannot leave anything in your trust or will directly to the pet. It has to be something that you set up for the needs of the pet, but not, you cannot say Fido is going to get $10,000. That won't work. You want to make sure that when you plan for the pet, that all of the pet's needs and idiosyncrasies are taken care of in the planning. So whatever the pet's feeding habits are and their medical conditions, their favorite toys and activities, special quirks, all of those kinds of things you can lay out in the trust and make that a part of what is done for your pet. And of course, with a trust, unlike a will, a trust is a private document. A will is a public document because you have to file it in court. So no one needs to ever know what you have in your trust. It's something that is kept private, and the only obligation is that the people that you name as your successor trustees, because of course with your trust you are the initial trustee, but you name successor trustees to take over, they must follow the dictates of your trust. Otherwise they can be subjected to claims for failing to honor the terms of the trust. If your pet, if you have an account for in social media for your pet, you certainly would want to let your new pet caregiver know about that so that that can be maintained. You don't want to assume automatically that your son or daughter or friend is going to want to take care of your pet. I mean, because even if they say yes and they're doing it begrudgingly, because they didn't receive fair warning or something, that's not going to make for a good situation for the pet. You always want to let the intended pet caregiver know that they will be caring for the pet and what you expect of them, and they're doing so. As I said earlier, it is required by law that you tell the intended pet caregiver that they have been named to care for the pet. And it's important to also know that you can't just name you can't say pets in general. The trust must specify the pet that you are intending to care for. So a statement that says, "and all my future pets," really is not a valid provision for a trust. If you have concerns in naming a person for taking care of the pet, and you were intending to leave money for that pet's maintenance, sometimes even with people that you know well, you may have some concerns about whether the monies will finally and ultimately be used for the pet's needs. So it may be that you want to name someone else in your documents to act as a pet trust enforcer, for lack of a better phrase. But basically what you might want to do is have some kind of check and balance that allows for this other person to determine whether the expenses in the account that's been set up for the pet are being used only for the pet's care. So it might be that you want copies of checks sent to that person, or bank statements, or quarterly reports, or whatever it may be that you determine is best for your circumstance. In addition to that, you may want to empower someone to make visits to make sure that the physical needs of the pet are being met, and that the environment in which the pet is being kept is one that makes sense for the pet. You certainly don't want to have your pet resigned to being locked up with a leash on a fence somewhere for the rest of his or her life. So that would be an important thing to consider. Now, oftentimes, of course, the pet will die, and there will be remaining money in the account that you had for the pet. And I strongly urge you to name Pasadena Humane as the recipient of those remaining funds, so that Pasadena Humane can continue to carry out its mission of handling those stray pets that are left, that 7.5 million in pets who are abandoned every year. Pasadena Humane has effectively done this for many years, and you can be of great service to pets in making sure that you support them in your planning, and make Pasadena Humane the final recipient of any funds which remain from that pet trust. Now, let's talk about other aspects of estate planning. It's a good time to talk about estate planning, because we all know that these are difficult times in our country. A lot of issues, a lot of uncertainty about what's going on. In our country, there are 15 million lawsuits filed annually. And of course, these lawsuits compound year after year. So the courts are clogged. In California and Los Angeles County recently, many of the filings that occur in the courts became so burdensome that where it used to be that you could go down to the court and file documents, now they want you to do all of this electronically, because it just became a little too much to handle. Over 1 million families approximately file bankruptcy every year, oftentimes as a result of medical bills. That's the biggest driver of bankruptcies. In the year 2022, the average for a nursing home stay, the national average was $112,296. And of course, it's much higher in California. Over 60 million people give aid and attendance to family members and friends, and there are countless lawsuits filed as a result of defective wills and trusts in our courts every day, every year. I can tell you, because I'm in court at least a couple of times a week, and I can tell you that that is a problem. People are fighting about things that shouldn't even be in the courtroom. People move on emotions in these kinds of situations, and as a result, the burden is on the system. One lasting problem that America has is that it has the third highest divorce rate in the world. It used to be that America had the highest divorce rate in the world, but proportionately, America was beaten out by Belarus and the Maldive Islands. So we're just number 3 in divorces. Go America. So just for a quick overview of estate planning statistics, 46% of Americans have a will, only 46%. And the number of Americans with a will is up to 46% versus what it had been in 2016 at 44%. Only a third of Americans aren't sure whether or not their parents have any estate planning in place. That's a continuing problem that we see in our office, in that people tend to become secretive about their estate planning, and that becomes problematic because when the time comes that the documents are needed, nobody knows where to find them. So that's something that when you think about what planning you do, think about how you're going to set up a system of communication to make sure that the people that you want to see the documents will see them at the appropriate time. Over and 26%, 26.8% of people aged 18 to 34 have estate planning documents versus only 22.5% of people aged 35 to 54. Now, you would think that that would be reversed, right? No, the younger population are considering their estate plans and their futures in a much more serious way than even older people are. So go figure. $59 trillion is predicted to be transferred from 94 million estates in the year 2061, and 7.6% of Americans don't know how to get a will or living trust. It's not that hard to figure out, but that's a problem for a lot of people. And we can't forget the very real dangers of coronavirus and other global health problems. In the state of California, the virus caused the deaths of approximately 100,000 people in just our state. And now they're finding even new strains of the virus coming out. And I read just the other day that it is likely that they will recommend that there be a yearly vaccine for the coronavirus. So these are very real dangers that impact us. And so oftentimes how it's handled is dealt with in a political way, but the ultimate impact to us is very real. So let's meet a typical couple this morning, Bill and Mary Jones. Bill and Mary live in Pasadena. They have an estate that they estimate the value to be about $700,000, and that includes their home. Bill is now retiring. He is got plans about what he wants to do, and Mary has stayed home and taken care of the children. Now, what I say here this morning will apply to you whether you be single, widowed, or divorced, and it'll become apparent where it applies to you and where it may not apply to you. Bill and Mary have two children. There's Susan and John. Susan is the responsible daughter. She's the golden child. Mom and dad can always depend on Susan to do the right thing. John, on the other hand, well, John has issues. He's always in trouble in some way or another. And mom and dad, rather than John supporting them, they still have to support him as an adult. There are many planning options that one can have when doing estate planning. One, you can spend it all. You know, I mean, I heard a statement made that, you know, I'm going to spend my child's inheritance. I saw a bumper sticker that says, listen, very succinctly, no dime left behind. Well, that's, of course, one way to look at it, maybe not the wisest way. Secondly, you could die intestate. To die intestate means you've done no planning. To die testate versus intestate means that you've planned. Another way to plan, and I've had people say this to me on many occasions, you know, Bill, I think I'm just going to put everything into joint tenancy with my children. I'm going to put my kids' names on the accounts, and I'm going to put their names on the house, and when I pass on, they'll just get it. And my response to that is always, I would think twice about that if I were you, because every problem that your child encounters in life will then become a problem for your assets. And even with the most responsible of children, stuff can happen, whether it be an auto accident or a lawsuit or divorce or bankruptcy, tax issues. whatever it may be, it then becomes a problem for you. So you might want to give more thought before just putting names on your assets that mean something for you, particularly as you get older. It's also a very important issue as it relates to your residence. When you put a child's name on your residence, let's say you bought a residence years ago and you paid $100,000 for it, and now it's worth $1 million. To put your child's name on that property means that they take the basis in that property. It's their value is at $100,000. So if they get the property upon your death, and if they decide to sell that property, they're going to have to pay capital gains tax on the difference between the date at which you bought the property at 100 and the date that they might sell it when it's $1 million. You're going to have to pay capital gains tax on that $900,000 difference. Whereas on the other hand, if you were just to leave the property to them in a testamentary fashion, meaning that it goes to them when you die through your will or your trust, then they receive the property at whatever the property's value is at the date of your death. So if the property is worth $1 million at the date of your death, and they decide to sell it shortly thereafter, they pay no capital gains tax at all. So you may want to think twice before putting names on your accounts, and particularly on your home. Many times people will tell me, I have a simple estate, and my obvious question is, well, what do you mean by simple? Well, generally people will say, well, I have a home, I have bank accounts, maybe they have an insurance policy and a retirement plan. And my response then is, well, you basically described 90% of our clients, because we all basically have the same things. It may be a question of the value of these assets. Somebody may have 2 cars rather than 1, or 2 homes rather than 1, but we all have basically the same thing. So when people come in and they say, you know, I just want to create a simple will, I don't want anything complicated. Well, that's can mean a lot of things to a lot of people, but you certainly don't want to just create a will. In the 30-odd years that I've been doing estate planning, I've only done 1 will. Because after I explain to people the difference between doing a will and doing a trust, the trust always wins out. The decision is made easy for them, because there are so many more benefits to doing a trust than doing a will. You can also choose to do a bare bones living trust. By that, I mean, you can always go on the internet and find a form. And you know, there's a reason why the forms are on the internet, because you know, you get what you pay for. So that may not be the best thing for you, because a bare bones living trust will mean that they are giving you the bare necessities with regard to estate plan, and not meeting many of the needs that you may have for your planning. Pardon me one moment, folks. I have something here in my screen that I can't seem to move out of the way. Okay, now what you can do is what we call create a family wealth trust. And that is a trust that is meant to incorporate all of the needs of the families with regard to protections, but also incorporate all of the legacy of the family into the planning. So, oh, did I go too far? Yeah. Okay, so with our couple, Bill and Mary, Bill's retired. You know, he probably had the same thoughts that all of us have when we think about retiring. You know, he's going to volunteer for the organizations that matter to him, take up those hobbies that he's always thought about having, and maybe start an exercise program. You know, he's been talking about exercising for the last 30 years, and this time he really means it. So let's say that he starts an exercise program, never consults his physician, and unfortunately has a stroke. He's now disabled. The problem in our country is that medical bills are a significant cause of bankruptcy. Over 66% of all bankruptcies are due to medical bills. And remember, the fact that you have health insurance will not stop medical bankruptcy. 75% of people who were involved in medical bankruptcy had health insurance. It may be that the premiums were too high for the people, for a number of different reasons why having health insurance will not be a determinant to your having to file bankruptcy. One of the bigger issues is that people think of health insurance only in terms of the type of insurance that will pay for their doctor's visits and their hospital visits. But remember, there's another step in dealing with insurance for health matters, and that is long-term care insurance. What are you going to do about your long-term care chronic health issues? Because your medical insurance does not take care of your long-term care health needs. That's why there's something called long-term care insurance. So if you have long-term care insurance or long-term care expenses, they can come in different forms. It could be that we're talking about a stay in a nursing home, or having assisted living with regard to your long-term care needs, or it may be that you're dropping a spouse or parent off to an adult daycare, or as most people want, if they have these issues, they want to have in-home care. The cost of care in Los Angeles area for the various needs with regard to long-term care can be pretty pricey. If you are looking for in-home care, that cost can be over this as of 2021, because we don't have 2022 numbers in yet, but it can be over $70,000, whether that be just someone who comes in and takes care of your needs with regard to the home, or a health aide that comes in. If you're dropping someone off to an adult daycare facility, the cost is close to $20,000 just for that. Assisted living facilities, the average is $63,000 if you were to go into assisted living. And if you wanted a private nursing home, the average cost is $135,233 in the Los Angeles area. And these prices go up 3 to 4% every year. So it can become very burdensome. And how many of us really can afford to take care of our lives otherwise and pay these types of costs at the same time? And that, again, is what drives medical bankruptcy. So how do you pay for long-term care expenses? One, again, health insurance does not pay for long-term care. So there has to be another way. And of course, the primary way may be that you have to use your own money. People want to do the honorable thing and take care of their bills. But what that often means for people is they spend their money until they're broke. You can buy long-term care insurance and hope that you get enough coverage and appropriate cost of living escalations. I know that long-term care expense insurance can be very expensive, particularly if you're buying a policy that is what they call a standalone long-term care policy. And of course, there is the issue of you qualifying health-wise to receive the policy. So that is an option if you qualify and if you can afford it. Now, there are other types of long-term care policies that have become much more popular. And one of those would be a long-term care policy with an insurance policy, whole life policy with a long-term care rider, which allows you to access the money whenever you want to, receive a reasonable interest rate, and receive a multiple of the amount of money that you contribute to the policy towards your long-term care when the time comes. Medicare. Many people think that, well, certainly in some way, Medicare will be available to pay for our long-term care needs. Well, you're right and you're wrong. Medicare will only pay for long-term care needs up to 100 days. And you have to jump over some pretty high hurdles to even get that. So I don't think it's fair to say, if we're talking about something that's long-term care, that 100 days is going to be all that you need or something that you should rely on. If you're a veteran and you served at least one day during wartime, you are entitled to certain benefits through the VA. Now, if you don't have the ability to pay for your long-term care out of pocket, and we know that Medicare is limited in what they will pay, and if you're not a veteran, that only leaves one other source for you to take care of your long-term care medical expenses, and that is Medicaid, which is known in the state of California as Medi-Cal. And of course, to qualify for that, you have to meet certain income and asset requirements. So going back to our family here, Bill is now disabled as a result of his stroke. He's not able to take care of his own affairs. And what about Mary? She now has to deal with not only taking care of the home, but taking care of Bill's new health challenges here. How is she going to do that? Well, they, of course, will look to the primary assets that they had. Bill was the one who was working in this couple, and he had an IRA that he obtained through his employer. And Mary thinks, well, okay, I've got to pay for Bill's rehabilitation. We've got expenses in the home since we don't have the same income that we used to have. Maybe what I need to do is liquidate the IRA. So with that thought in mind, Mary goes to the IRA administrator and says, listen, my husband and I have an IRA. I want to liquidate the IRA so that I can pay for his care. The IRA administrator gives Mary some surprising news and says, you know, Mrs. Jones, I would like to do that, but I can't. You cannot liquidate this IRA. And of course, she's just amazed that this is even something to be an obstacle for her, because she's always considered this their IRA. But the reality is that the IRA is in the name of Bill, with Mary as a beneficiary. In order for Mary to access that IRA, she would need the authority of Bill, because he's not dead, he's still alive. But the problem is that he's disabled and can't give her the permission that she needs. So she can't use the IRA for Bill's care. Her next thought is, well, okay, we've got this big house. We've been living in it for 30 plus years. The kids are out of the house now. I think I'm going to sell the house so that I can take care of my husband's care and take the burden of these other expenses off my shoulders. So she goes to a realtor and says, listen, I want to sell the house. The realtor says, well, Mrs. Jones, I'm afraid that you're not going to be able to do this, because we need the signatures of both you and your husband on the sales contract. And again, Mary's thwarted. She doesn't know what to do. She can't sell the home, which was one of our major assets. She can't get to the IRA. She doesn't know what to do. So in addition to that, you know, Bill's now disabled. The likelihood is that Bill will have to be subjected to a procedure in California known as conservatorship, oftentimes referred to as living probate, because it's handled through the probate court, but doesn't involve a death proceeding. So Mary will find herself having to file a petition in probate court to have herself appointed Bill's conservator so that she can make decisions for Bill under the authority of the court. Now, whenever a person is mentally or physically disabled, an adult, that is what is likely to happen for that person in many circumstances. Conservatorships are truly a terrible place to experience. I've been in court many times and seen people going through conservatorship proceedings, and you know that the person's not there unless they had assets. And people are treating the person like they don't matter, and they talk around the person. And if the person even wants to speak up, the court's likely to say, Mrs. Jones, please let your attorney speak for you. That's got to be frustrating for Mrs. Jones. But the conservatorship proceeding is truly a nightmare because it takes over your life. You are now essentially a ward of the court. It's humiliating. The court is in control of your life. It's time consuming, and all of your personal information is exposed. And it's very costly because you're going to have at least 2 attorneys charging at an hourly rate. And remember, all the costs of the conservatorship come out of your assets. All the attorney's fees, the conservator fees, the court costs, the bonds, all of that would be deemed necessary by the court will come out of your assets. And remember that a conservatorship by its nature is a long-term procedure. So you're going to be a conservatee for a long period of time with attorneys charging against your assets and the court costs, etc. You don't want to leave yourself exposed in that way. If you have a choice, and you of course do have a choice, you don't want to leave your life to chance in that way. You want to have a plan of action by which you've already named your legal caregivers, and you can do that under your living trust. Now, in the case of Bill and Mary, they only had a will. And of course, a will does not avoid probate. What a will does is guarantee that you must go through the probate court process, because wills by their nature must be probated. So if you in a death probate process, what that means is that you are there to resolve disputes, pay creditors, marshal the assets of the estate, change title to the assets, and ultimately distribute the estate to the heirs or beneficiaries named in the will. These are the costs as to why one should consider doing a trust versus allowing themselves to be subjected to probate. It's money that should go to your families, but often will be going to attorneys or the estate administrator. And these are because the attorney and the estate administrator each receive a percentage of the gross value of your assets. So if the larger your estate, the bigger the fee. And of course, that's truly where most estate attorneys make most of their money, because we do get a percentage of your assets, and the administrator gets the same percentage of the assets. And in addition to that, both the attorney and the administrator are able to charge for extraordinary services at an hourly rate. So whether that be helping to sell a piece of real estate, or being involved in resolving tax matters or litigation, that is an additional charge to the percentage that they get. Being in probate court means that you're going to be in a process that is very time consuming, because as I may have mentioned, I think I did, that even the simplest of probates is going to take a year in LA County. It's open to the public. Everybody knows what your assets are and who's likely to get them. And the fact that they know who's likely to get them and the records are open to the public is one of the reasons why Los Angeles County has often been referred to as the scam capital of the country, because it's very easy for anyone to go down to the court. They have an open file room down there in the court, room 112, where anybody can pull files of anybody's estates. find out what assets they had, who's going to get them, and approximately when. And that is what helps the scammers go out and find the surviving spouse and come up with whatever creative reason they can, whether it be, listen, I'm here to put a roof on your house or whatever it may be, that will scam them out of the money. And I know that I've had seen this happen with people a number of times over the years. If you have assets in more than one state, you have to have separate probates in each state. So separate filings of petitions for probate. If you had property that was left to you in Texas, you're going to have to file a petition for probate there with a separate administrator, separate attorney, separate court costs, etc., all of which could be avoided. So in our example, let's say Bill has died from his stroke, Mary lives another 10 years. It is not uncommon for assets, though this may seem counterintuitive, but it's not uncommon for estates to grow in value as time goes by, and mainly because people are not spending as much. They have assets like real estate, particularly in California, where the values go up. So it's quite conceivable that Mary could now wind up with an estate that's, say, twice the value it was with our example at 700, and let's say it's now 1.4 million. But as time goes on, Mary winds up having a health issue. She starts to develop Alzheimer's. Half the elderly end up in a nursing home at some point. Mary's unable to handle her affairs. Her daughter, her responsible daughter, Susan, goes through Mary's documents and finds a power of attorney, because maybe having experienced what she did with her husband, Mary knew that there was something additional that she needed. So she had a power of attorney prepared, naming her daughter as her caregiver. Now, Mary looks at these documents and determines that she has an idea as to what it says, but she wants to take it to an attorney. So she consults an elder law attorney. And that elder law attorney says to Susan, we can protect most of your mom's assets, but it will depend on what the power of attorney says. Does it provide the language that will enable this? So she looks at the document and she finds that it does not contain any estate planning provisions that would have empowered Susan to move assets out of mom's name so that she can qualify to receive Medicaid benefits, as opposed to losing all that she has. It's an inadequate power of attorney. And that is one of the problems with the bare bones types of documents. Oftentimes they are inadequate because they have just made the documents as simple as possible, which may sound nice, but it can be to your detriment. Most estate plans fail because the documents are canned. Many people will just go get a form, and I understand that. It's you think of it as being a trust, as being the same as any other type of asset. If you get a trust here, it won't be any different than if you get a trust there. You buy a Ford at one dealership, same at another dealership, etc. There are many the estate plans fail because they've done nothing with regard to long-term care planning. In our office, we practice elder law. And elder law is basically about making sure that you have a plan of action to protect people's assets as they grow older, so that they won't lose them to things like long-term care expenses. Plans also fail because people have maybe saw an ad in the paper, and they get the form trust that they get from those kinds of ads. And the ads generally require that the person do all the titling of their assets in the name of their trust. They give them written instructions to do it, but many people don't do it because it's out of their wheelhouse. It's not something that they're used to. And so it never gets done. And that is a common occurrence. plans fail because there's no remarriage protection. How do we make sure that the assets of the trust that Bill and Mary created together are protected? What happens if Mary were to marry somebody? How do you make sure that those assets don't leave the family and wind up with that new spouse? The plans fail because there's insufficient protection for the heirs, and many people have had their plans done and it was a one-time transaction, but nobody has kept them up to date about all the changes in the law that occur over the years that they have the trust. And of course, if nobody told the person, how would they know? They depended on the professional to let them know about these things, but most times it's just a single commercial transaction. You give me a check or a credit card and we'll give you a stack of paper, and that's the end of the relationship. Not the best way to do it. So an estate plan is a way for you to centralize the management of your assets, to deal with all these issues having to do with Medicaid planning and remarriage protection and divorce protection for your children, and dealing with irresponsible beneficiaries, and a myriad of different things that affect us in life. So let's give Bill and Mary a quick do-over. This time, Bill had the same list, and he and Mary as to what they plan to do. But this time we're going to have the type of trust that would benefit Bill and Mary in place. Bill has that stroke, but this time they had a clearer understanding. They know that estate plans are not commodities. It's not like you buy one document here and it's the same as what you might buy in a full-page ad from a newspaper or a legal Zoom. They do differ. These things need to be made so that they speak to the particular needs of your family. So this time around, Mary is she and Bill created this trust together. Mary was the co-trustee of the trust. When Bill dies, Mary has immediate control of all the assets, and she will have the authority to deal with things like the IRA and the financial accounts and the home if she wants to sell it. After Bill has passed on, it might be that Mary has a suitor, next door neighbor Ralph. Well, Ralph's experience was that his wife had developed Alzheimer's, and they wound up having to spend all of their money to take care of her before she died. And now Ralph doesn't have anything left. In addition to Mary being an attractive lady, he's seeing that maybe, and if he's unscrupulous, that she has money. So the question is Ralph coming for love or money? Well, if you do the plan right, Ralph better be coming for love, because he won't get the money. You can keep it in the family with a prenuptial agreement, so that if Mary were to decide to marry Ralph, we can have prenuptial language in the agreement that prevents, in the agreement that she did with Bill, that would prevent Mary from commingling those assets that Bill and Mary created together with any assets with Ralph. So it gives Mary an out if she decides to marry Ralph, and she can show him the document that says, listen, you are prevented from doing this. And Ralph, it shouldn't have any impact on the marriage. And if that was his reason in the first place, maybe he will decide that he doesn't want to get married. This time when Mary gets Alzheimer's, she won't have the same concerns about who's going to take care of her life, because she will already have named Susan to be in charge of her trust and of her needs under the powers of attorney. So she will get the attention, the care that she needs. There won't be any conservatorship proceedings for either Bill or Mary. The costs, which can be exorbitant and take away from the legacy that Bill and Mary would like to have had, and the monies they would like to have left for their children. Neither Bill nor Mary's estates will have to go into probate. because when you have your assets in a trust, that avoids probate. Probate is about death. If the assets are not titled in the name of the person who died, but instead are titled in a trust, well, the trust never dies, and therefore you avoid the probate court process. There will be no need for death probate on all those costs and public exposure and long delays that that occur with probate, and there won't be a need for additional probates in other states because you will have all of your assets in your trust. Now, if you have a well-done estate plan, it should do more than consider just your assets. It should also consider the family legacy. When Bill and Mary just had a will, they had no consideration given to the family's history, the stories, the wisdom, the experiences that they have had, that they would love to pass on to their children and future generations. When we do a well-drafted trust, there are many types of sub-trusts that you can create, depending on the needs of your family. So one of the sub-trusts would deal with the issue of Mary's remarriage or Bill's remarriage, whichever one of them was the survivor. We might also do divorce protection sub-trust for the children, so that if you leave monies to the children and they should divorce, that son-in-law or daughter-in-law will not be able to make a claim for the monies that they receive. The same thing can be done with regard to sub-trust for dealing with your retirement plan, retirement benefits, your grandchildren, if you want to set up sub-trust for them to let them know that you had them in mind in your estate planning. Guardianship sub-trust, sometimes people are in same-sex marriages and they have children. You want to, or same-sex relationships and they have children, you want to set up a guardianship sub-trust. You definitely want to set up sub-trust for people who have special disabilities, because you want to make sure that those monies, if you leave them to that person, they will pretty much wind up going, that money will wind up going to the state. But if you set up a special needs sub-trust, you can protect that money. If you have beneficiaries that are not living up to their potential and you want to incentivize them to do better, you can create sub-trust for that. And if they're blended families, you want to make sure that you have planning that will consider the children from prior marriages, prior relationships, to make sure that everybody is treated fairly and not in such a way that you leave everything to the surviving spouse and then everything goes to that person's children and the children from your relationships are left out in the cold, which happens often. So it should be noted that not all trusts are created equal. There are trusts that will deal with basic things like avoiding probate and avoiding conservatorships. But one of the things that I have observed over the years is that you do not have an adequate estate plan if you do not have a plan that doesn't contemplate what happens with the long-term care expenses that come about as a result of aging. I mean, that is going to be a consideration statistically, according to the U.S. Department of Health, for most of us. So you want to have a trust that has Medicaid strategies in the trust so that you can have a way of protecting your assets and have a different way of having those medical expenses paid, typically through Medicaid. So the question now is exactly when do you intend to take care of all this? Remember, it's very easy to keep kicking that can down the road, but at some time the road ends and you don't know when that'll happen. So when is the best time to make a decision is when the information is fresh in your mind. So if you know that this is something that you need to do, probably the best time to do it is when you have the information. There's no more reason for you to keep delaying it. No more I need to get additional information. You know what you need to do. It's question is whether you're going to do it. So a life well lived can last for generations. You can benefit your children and your great grandchildren and the extended family by doing proper planning, particularly in that way that you will have to pass on the family stories by leaving a written legacy, which is a part of the type of planning that we do, that will be as valuable as the money to future generations. That, because I don't know about you, but there are many people that in my family that I wish I could have talked to before they passed on when I was younger, and I will never be able to get that information ever again. So think about that in your planning. So I think I will turn this back over to Mia Dunn at this point, and she can give you her presentation with regard to Pasadena Humane.
Okay, thank you, Bill. That was a really wonderful presentation, and I hope all of our attendees found it very interesting. We will take, I won't speak very long. We will take a few questions, and you can put them in the chat. And I do see that there are two in there that I will address because they're concerning Pasadena Humane, but please feel free to write any questions you have in the chat function. As I said at the beginning in my introduction, you know, you may or may not be considering a planned gift to Pasadena Humane, but if you are attending this webinar with that intention, the screen or the slide that's on your screen right now will show you the different ways that you can make a gift to Pasadena Humane. And if you do decide to do that and you let us know, you would become a member of our 1903 Society of planned giving donors, and we do have special benefits for people that choose to do that. One of the questions was from Lynn, I believe it was Lynn, yeah, about the pet trust. And it's kind of, I guess it's sort of a two-sided question. You, as Bill said, you can create a pet trust to care for any pets that you may leave behind. And within that trust, you can designate money for their care. And if the time comes when those pets pass and there is still money left in that particular fund, you can make an additional designation that any leftover funds come to Pasadena Humane as a bequest. Alternatively, what we do is when people are making their estate plans and they do have pets, we do encourage everybody to name someone to care for them when they pass, but we realize that not everybody can do that. A lot of people have family scattered all over the place, and they don't have any close friends that they would want to care for their pets. So if there really is no other alternative, if you do name Pasadena Humane in your estate plan in any capacity, you know, as seen on the screen, and you don't have anyone else to care for your pets, we can step in and we can take your pets and we can care for them and find them homes. And you don't necessarily need to create a separate pet trust for that. You just need to designate us as a beneficiary of your estate plan in some capacity. And it's up to you whether you want to also set aside a certain amount of money to come to us to care for the pet. Again, that's up to you. You could just you don't have to be that specific. You just need to name us in your estate plan. So I hope that answers your question, and I can communicate with you further on that if you want to talk about it further. And we have the next slide with our trust guide too. Yes, and one thing we're pleased to announce is we've been working with the law firm to create this guide to pet trusts, and it basically distills all the information that Bill mentioned at the beginning of the webinar. And if you would like a copy of this, absolutely free, all you need to do is contact me, or you can actually contact the law firm because they have copies of it as well, and we can email it out to you, and then you'll have it at your fingertips, all the information that you need to know when creating a pet trust. And I see that there was another question about what does Pasadena Humane do with pets who are not adopted, that were not not a no-kill shelter. Actually, so we do not have a time limit or anything like that on the pets that are in their care. As it just however long it takes to get them adopted, we work. We work to get them adopted. We have adoption fairs. We have special adoption days, and so we do everything in our power to make sure that those pets all find a home. We do actually meet the threshold of a no-kill shelter, but we choose not to use that terminology because in many cases it's a misnomer, because no-kill does not mean no euthanasia. A lot of shelters that bill themselves as that actually that doesn't mean that they don't euthanize animals, because especially if an animal comes in that's suffering irremediably, the most humane thing to do, if there's no other options, you do not want the animal to suffer. So that's one case that there would be a euthanasia in that for that reason, for that humane reason. Our terminology is we are a socially conscious shelter, which in very briefly, it means that we take a holistic approach to animal care here. We create pathways for every animal that comes into the shelter, and we have a team made up of members of various departments that work on all aspects of that animal behavior, health, training, and to make sure that that animal has the best chance and the quickest chance for adoption. So if you do go to our website and you go under the About Us tab, there's actually a longer explanation that explains what we're all about and how we ascribe to the 6 freedoms and everything that we do to care for the pets. We do serve 11 contract cities, and we are required by those contracts to accept every animal that comes into us, no questions asked. And so in some cases, an animal will come in, like I said earlier, that will be suffering irremediably, and we do not want it to suffer. And so then in those cases, they would be euthanized. So, but that is just when you're in that position, when you do accept all the animals that are in the areas that you serve, that does sometimes happen. So and as I said, that makes the term no kill kind of not exactly 100% accurate at times. So I hope that wasn't, I hope that answered your question, and I hope that didn't confuse you. But as I said, you can go to our website and there is a much fuller explanation and better explanation than probably what I just said. But so if anybody has any other questions, Bill Lynn had also asked what the annual yearly sum mentioned for nursing care is.
For a private room, the average for the Los Angeles area is $10,292, and it's I think it came to $133,000 and change annually.
Okay, and I see a question from Pat about the wills guide. Yeah, if you I can send you both if you are interested. I do have your email address, so you can ask for either one. We do not have the pet trust guide on the website yet. We literally just finished it, but it will be up there soon. But in the meantime, I can send both documents to you if you'd like them. That's no problem at all. We will have another slide coming up that will have my contact information. So if anybody wants to jot that down and get in touch with me later, I'd be more than happy to speak with you and answer any questions that you have. And then another one of our attendees asked, what's the range of fees you charge for a quote unquote well done estate plan for a single person with no children for a basic trust, so residence, retirement account, IRA, et cetera, valued at about $2 million, and all the proper documents, trying to get a feel for the range of fees charged by experts like yourself.
Yeah, I'm going back to Lynn's question. The average for the nursing homes, that $10,292 has increased. So the number is closer to the $133,000. So But in terms of the fee that we charge $4,500. So it's a flat fee. Yeah, we typically get 60% of the fee to begin, and the balance once we complete the documents. It usually takes about 3 weeks to do it.
Can we move to the next slide with our contact information? So
Sure.
Yeah. Okay, so so if you have any questions, either of Bill or myself, up on your screen is how you can get in touch with us. And I would be very happy to talk with any of you further if you are considering leaving Pasadena Humane in your estate plans. If you do that, you can even designate a particular area that you would like your future gift to go to. Most of our 1903 Society members don't do that. They just, wherever it's going to be needed. But we do have some folks that have said, well, I would like my future gift to go to the cat program or the dog program, or, for wildlife, or for your Helping Paws program. So really, you have the option of doing that as well. And if you are interested, we do have, I do have a brief form that you can fill out that letting us know of your intentions. You don't have to do that, but if you want to, it helps us in the future because we can create a file for you, and then anyone, so that your future gift, your wishes will be carried out as you intended. And of course, something like that is not binding and it can be updated at any time. So if anybody has any more questions, please ask them now in the chat, because we'll be wrapping this up in another minute. Again, I hope everybody found this interesting, and I thank you again for spending your time with us. So I do not see any more questions coming in. So with that, I will say thank you so much, Bill.
Well, thank you.